It's a wonderful privilege to introduce Daniela. I can't help but mention that she's my former PhD student. So this is one of these really emotional moments where you feel you're passing on the torch. She is the keynote speaker. It's wonderful. She has an ERC project on this subject matter, and we're very keen to give you the 15 minutes to let us know about your project. Daniela, floor is yours.
Thank you very much, Ruth. It's wonderful to see you again. Thank you, Siri, for the invitation, and thank you all for being here, especially the panelists. Can I have the clock so that I can see it, or because I tend to talk maybe a bit too much. So, and as you can see, the topic for today is very broad, or there are very sort of big topics: legal inclusion, identity, and the politics of belonging. So I will at least scratch the surface of these, and then also give a specific example drawing on the Finnish context. So I will start by talking a little bit about my current research project, and then go on to talking about legal inclusion and exclusion, focusing on indigenous peoples, indigeneity as a legal category, and then coming to the renewal of the Finnish Sami Parliament Act, which illustrates many of these questions. I have previously been researching rights developments in the Nordic countries, or focusing on the Nordic countries, and the Nordic countries' ambiguous legal relationship to human rights violations in their recent past. And that's how I came across also the ongoing, or finished in the Norwegian context, truth and reconciliation commissions. So I am not indigenous myself. I'm coming at this very much from a human rights lawyer and a socio-legal scholar angle. But I discovered that there were these ongoing at the time truth commissions regarding or involving the Sami people, who are the indigenous, or the people indigenous to Sapmi, which today forms part of modern Norway, Sweden, and Finland, and Russia. So there were these 3 Truth and Reconciliation Commissions in Norway, Sweden, and Finland. And that is very remarkable, first of all, to have truth commissions in the Nordics. I was very intrigued by this as a legal development, and I was also interested in the fact that this was not really perceived as a legal event. Questions about state responsibility were not really asked. So this is also how I am coming at this topic, asking questions of state responsibility. And if you're interested in the project, you can look at the website. It's listed there. I would like to start with a short video published by the Swedish Truth Commission that looks at oppression against the Sami people, because I think that it illustrates, it's sort of a glimpse, it gives you a glimpse of the issues at stake. So if you can show it, please.
Mun on Lena Kroik, vuorinen sistiebuotem. Man är sanningskommissionen Barkminje. Jag tror att det är första gången som man har frågat det samiska folket vilken påverkan och vilka effekter och vilka konsekvenser har politiken lett till i just ditt liv. Och det är bra, det finns en tyngd i det som jag tycker är.
So if you're interested in this film, I recommend you to check it out. We can go maybe back to the slides. If you're interested in the Marsen project, you can also look at the website, or you can come and talk to me. I would be happy to tell you more about it. So we are looking into the transitional justice processes, which questions are being included in those, which questions are left out. Also looking at the legal governance of indigeneity, also looking at rights development, looking at the governance of indigeneity over a historical period over the last 100 years in these 3 countries, and also looking at some in-depth examples of Sami rights mobilization. So this is the Sami flag here in this picture. So what does I think this is a good way to connect also back to the film, because the secretary of the Truth Commission there was saying that this is the first time that the Sami people have been asked about the consequences of these policies. So these policies is really examples of settler state exclusion of indigenous people or the indigenous Sami. And one example of that is forced assimilation. And the Truth Commissions here are really unique moments or opportunities for inclusion and asking questions about state responsibility. Not saying that that will necessarily happen, but it's at least opportunities. Yes, so indigeneity as a legal category. As all kinds of legal categorization, it involves inclusion and exclusion into groups, and that's typically done by nation states. So typically nation states are the one who categorize and define and determine who can belong to a group, who is excluded, what does that belonging entail. The function of that categorization has, of course, been settler colonial governance, also racial governance. For example, in the wake of the eugenics movements around 100 years ago, there was also this kind of racial mapping of the population in these countries, and there the Sami were considered to be inferior of the settler population. So this is kind of one way that this categorization plays out. Of course, the category of indigeneity also entails certain rights. It has historically entailed rights to mobility, but also with the development of supranational and constitutional rights, it entails indigenous rights. What we can say about this category is that it's changing, it's not static, and that in especially the UN Declaration on the Rights of Indigenous Peoples, the importance of self-determination is really emphasized. So who should decide about this category is really a collective right that belongs to indigenous peoples. So a case that I think illustrates many of these questions, and it's a very complex case that I can really only scratch the surface of, is the renewal of the Finnish Sami Parliament Act. I think this will be one of the cases that we look at the mobilization around, because it has been such a prominent discussion in Finland for the last 30 years. So the old section on the Act on the Sami Parliament in Finland, so this is the Finnish definition, and that said, in Sweden and Norway, the questions are, and the legal definitions, they are not identical, and it's important to take these contexts into consideration. But the Act on the Sami Parliament, so the Sami Parliament is the primary representative body of the Sami people in Finland. So it has also determined then who can vote or run for office. And it has had the definition of who is a Sami person. This is the official translation here. So it has contained one subjective element, which is self-identification, but it has also contained a reference to a linguistic criteria or another criteria on previous registration for the Sami delegation or the Sami parliament, and another criteria which is a reference to these old land taxation and population registries. And that is perhaps the criteria that has been most criticized among these so-called objective criteria. So as I said, this has been controversial since its foundation, and there have been several attempts to renew this act, and several theses have also been written about this. The Sami parliament, that should be said, is a legal person, but it has limited powers. It cannot enact legislation or so. But of course, with the principle of free, prior, and informed consent, the state should consult, and the Sami people, or the Sami parliament in this case, especially should give consent to any projects that affect their rights or interests, such as these many infrastructure projects, now also military projects, especially with Sweden and Finland joining NATO, mining projects, forestry, you name it, big money, big industries. The Finnish Supreme Administrative Court decided in 2015 to, against the will of the Sami parliament, accept many new voters to the Sami parliament, and they decided to scrap the objective elements and say that only individual self-identification is enough. That has led to quite well-founded fears of exploitation. Will this lead to the Sami parliament being co-opted by people close to these industries, for example? And how will this play out in terms of protection of Sami culture and traditional livelihoods? Will it eventually lead to the erasure of identity? And there have been several cases that have addressed these questions. Two before the UN Human Rights Committee, and one before the Committee on the Elimination of Racial Discrimination. And they have all been successful in the sense that these committees have found violations and said that the Finnish state has to make sure that the act on the Sami parliament is revised. So here we can really see also the kind of tension between individual self-definition and group self-definition, because of course what also these committees have found is that what we are talking about is a group self-definition. So the Sami people should decide, and it's not just individual self-definition. We have a new section now, so just a couple of months old actually, and this one of the elements of the former section has been taken away, which is the reference to these old population taxation registries, and this has also been the new title is Right to be Registered in the Electoral Roll, which is I think also more correct. The new act has been generally welcomed, and it has been prepared in cooperation with the Sami parliament and Sami organizations. I think that you can see also a clear impact of the UN Declaration on the Rights of Indigenous Peoples in the background, and also the mobilization effectively utilizing this. There have also been some fears of exclusion now in the media. So will some Sami groups be excluded? But it's very early to say, of course. Something that I find interesting is that now when there are two objective criteria, the importance of Sami languages is also increased. But what's rendered invisible in this is that the Finnish state continuously fails to protect Sami languages and provide enough resources for these languages to be lively and actively used. So it's kind of an individualization also of so that this is kind of an individualization of the responsibility to individual Sami families, basically teaching Sami languages to their children. That said, now when this question that has been really the focus of Sami mobilization, the Sami parliament has a lot of resources on these questions. Will there now be more time and resources to also look at land rights, for example, and will Sami self-determination and the principle of free, prior and informed consent be respected? In general, in Finland, it's often quite blatantly disregarded, to be honest. And in terms of also the Truth and Reconciliation Commissions ongoing, will this lead to increased self-determination of the Sami people? That's it for me. Thank you very much, and I look forward to the discussion and the other interventions. Thank you.
So we have a wonderful panel here. Anna Carolina, who already spoke today, will also contribute to this panel. Then we have Aurora Maggi from University of Siena. Lynn is with us. Where's Lynn? There she is. From Southeastern Norway, University of Southeastern Norway. And then Zanele Malindi from University of Witwatersrand. I don't know, I think Zanele, maybe I'm going to ask you to take the floor. Sure. Each of you has 3 minutes, maybe, yeah? So please go ahead and engage in whatever angle you want to engage concerning indigenous subjectivity, which is such a difficult and complex question. Go ahead.
Thank you so much, Ruth, and thank you, everyone. So the framing for this panel about who defines indigeneity, how law governs belonging and access, and how colonial logics are reproduced in participatory processes are very relevant to my research on South African conservation law. So my project examines how conservation governance in South Africa has been built on exclusion. Protected areas like the Kruger National Park, which is my case study, are celebrated for their biodiversity preservation, yet their very foundations rest on violent removal of indigenous communities and the erasure of the knowledge which they hold. The law frames these removals as neutral or even benevolent, but in reality, they reproduce colonial and apartheid patterns of dispossession and exclusion. So many South African laws were not repealed after 1994, but simply amended to varying degrees. This means that legislation designed under apartheid with the explicit purpose of exclusion still forms the backbone of our legal system today. The same is true for conservation law. The Conservation Act of 1989 carries forward a framework that was never intended to serve indigenous or black communities, but rather to control and to restrict them, and prioritize the protection and profit-making abilities of animals and plants rather than honoring the relationship indigenous people have with the land. When we continue to rely on laws born of dispossession, we cannot be surprised when the outcomes reproduce that same dispossession in new forms or under new names. So I found that this exclusion operates on 2 levels. First is through the physical displacement of communities. Communities are cut off from their ancestral lands, culture, identity, history, and livelihoods. And then second is through the episteme side, especially that held by rural black women, who have historically in South Africa acted as custodians of ecological knowledge and caretakers of land-based practices. Conservation law privileges Eurocentric knowledge, even when indigenous practices, which are often shared communally and orally, have sustained ecosystems for generations. This hierarchy of knowledge becomes increasingly contentious in academic spaces, where global north and white voices on these topics, even those on indigenous peoples and their knowledge systems, dominate and are considered more authoritative. My project uses 3 frameworks, epistemicide, ecofeminism, and storytelling, to imagine alternatives to land stewardship. So ecofeminism highlights how patriarchal and colonial systems treat both land and women as objects of control, rendering them extractable, manageable, and expendable. While storytelling centers oral traditions and lived experience as jurisprudentially meaningful. And this invites us to reframe how we understand law, justice, history, and the truth. It reveals law not just as something that is codified in legislation, but as something that is lived, felt, contested, and remembered, and allows for an understanding of conservation and land, not just as a policy decision, but as a narrative of place, memory, loss, and resistance. By treating community narratives not as anecdotal, but as legal authority, I'm looking at how conservation law might evolve if indigenous epistemologies were recognized as equally valid sources of governance. Belonging is asserted through language and narrative, through naming, storytelling, and oral traditions that carry memory, law, and ecological wisdom in ways that statues simply cannot. Ultimately, my argument is that conservation and indigenous rights are not mutually exclusive. In fact, conservation cannot succeed without indigenous stewardship. Reimagining law to honor indigenous knowledge is not just an ethical imperative, it is a practical one if we are serious about ecological justice and climate resilience.
Thank you. Thank you, Zanele, for bringing also women's voices. I mean, you seem to talk about indigenous identity, but you know there are identities within identity, and that again poses interesting challenges about collective versus individual self-definition, right? All right, so I'm going to invite Ana Carolina to be next.
Sure.
And I know this is kind of aggressive, but
Yeah,
it's
just
also
do it.
very fair. Go ahead.
Okay, so thank you, Daniela, for your keynote. I also want to thank Oyvind, who over the past year has been through exchanges. He taught me a little bit more about the Sami people and the history here, in Norway. So I've been learning a lot. And I think I want to comment on 2 points, which are not as well elaborated as we just heard, so I'm sorry. The first one is that I think I want to say that there's a lot of research, I think, to be done on this issue of how the legal category of these different identities have evolved and changed. So really the trajectory of this category of indigeneity or other categories in different jurisdictions in different places, I think there's a lot of interesting comparative work to be done. Yeah? So one thing is that in my country, collective identities have really been an obstacle to the inclusion of territories into capitalist circuits of accumulation. This is a fact. And so agribusiness, the agribusiness caucus, extractivist representation in Congress has made it clear that their goal is to weaken the protection of identity-based land tenure regimes, and they have done this very well. So today we have a whole body of social environmental legislation and indigenous legislation which was thought up by agribusiness and by the extractive sectors. And what they do is either they reduce the protection of these identities, or they outright say, you can be whatever you want, but you'll only have voice as indigenous if your land is demarcated or if you are up to 5 kilometers away from this project. So they think of criteria as just to, you can be whatever you want, but you're only included, you only have voice if these objective criteria fit. So it's kind of like saying we don't really care. We're not even going to think about what's indigenous and what's not, because agribusiness and the right, they will lose that discussion because it's a discussion about traditionality, about identity that they don't have the bandwidth to think about. So they simply think of laws to exclude. And I also want to say that when we talk about inclusion, we're thinking about the inclusion of people, of groups, but also of territories that are outside of an accumulation frontier, and how they'll be included into the circuits of capital, and how they'll be re-excluded again. So through the reclaiming of lands, the resignification of land that was used for soy plantation, for extractivism, new frontiers that were closed, they're reopened. To think of new forms of inclusion. So I'm thinking about the inclusion of territories as well, of land. And the third and final point, I can see it's going to do a thing, is that we're going through a very peculiar moment in Brazil right now, and I don't want to not say this, because I've been seeing so many pictures of, the Supreme Court and Justice Moraes and blah, blah, and this is all really important. And we have this global debate today about the tariffs, and big tech. And what's been happening in Brazil is that this is kind of hyper-stimulated the mythology of sovereignty all over again. So of course it's great that Justice Moraes and the left and Lula are protecting Brazil against the American government, but what's happening now is that that whole like national development, unified identity, the unity of the nation in the left that is stronger than ever before. And what that does is it weakens the plurality of land tenure, of territories, of jurisdictions, of identities, of everything that we've been talking about today. So it's kind of like something, oh, it's great, sovereignty is being defended against Trump and the global order, but internally, this has been kind of weakening once again the plurality, the multiple jurisdictions and possibilities and voices in the country.
Thank you, thank you. Anna Carolina. So, identity versus identities and the risks and the cooptation of identity politics to disguise redistributive and pre-distributive injustices. So thank you so much. What don't you take the floor now, Aurora, and I will threaten you with my term.
Thank you so much. Today I would like to share some reflections on the right to abortion and indigenous women in Latin America. In recent years, we know important progress has been made in countries such as Argentina, Uruguay, Colombia, and Mexico, where abortion has been recognized within certain legal limits. Despite these advances, indigenous women often remain excluded from the effective exercise of these rights. This happens because women face a double disadvantage: linguistic barriers that prevent communication with healthcare providers, for example, or also problem of social-cultural differences that stigmatize their choices, and other types of logistical barriers and long distances from hospitals, for example, and clinics. These obstacles push many indigenous women toward unsafe and clandestine abortion, which remain one of the leading causes of material death in the region. The Green Wave movement in Argentina, for example, and in other countries remind us that abortion is not a simple procedure, medical procedure, but it is a fundamental human right. And in this context, the World Health Organization, the Pan-American Health Organization, also stress to need to eliminate unsafe abortion as a matter of public health and human dignity. A milestone case in 2023 of the Mexican Supreme Court declared unconstitutional the Federal Criminal Code that interlike criminalized voluntary abortion. This landmark decision resonates across Latin America and open at new possibilities for change. But in this context, in other contexts, the European Parliament has raised concern about violations of indigenous people's rights, including the denial of reproductive self-determination and of indigenous women. And in its resolution, it underlined the importance of dialogue and mutual understanding, because only acknowledging cultural differences can we take the first step toward truly recognizing rights. So the question before us is not only legal for me, but deeply ethical. How do we ensure that the right to abortion, already recognized in law, becomes a real and accessible right for all women, including indigenous women? It's necessary to recognize that women suffer a double violation. It is important understanding that violations of indigenous women is so different than other forms of violations. Because the indigenous women live for two forms of discriminations, because are indigenous, because are women, and the need to acknowledge this interconnection persists, and it is the central point to change the complex situation. Thank you so much.
Thank you, Rora. I think it's wonderful that you remind us that when we think of the indigenous subject, of course, the automatic connection is to land and livelihood, but of course, you know, reproductive rights, when you think of a female indigenous subject, must be centered. And I see there is a growing agenda about indigenous women's rights. And I think it's interesting what it will do to the overall perception of indigenous subjectivity. Okay, Lynn, it's your turn. Go ahead.
I want to start by saying thank you to you, Daniela, first, and also to Eivind and the rest of you for the possibility to be here. During the days that have passed, several has emphasized the importance of narratives and how each context has its own struggles and structures to decolonize. I will give some brief reflections from the Norwegian context as a majority Norwegian, where conflicts over land is intertwined with indigeneity, history, and politicized identities. In land disputes in Norway involving reindeer herding, ethnicity often becomes a central component. Reindeer herding is an exclusive Sami right within the reindeer herding districts, and is protected by international and constitutional law. When land disputes involving reindeer herders reach the media, it doesn't take long before comments about Sami ethnicity starts. Comments like this from 2 months ago, from a random article in Aftenposten, it could be many others, where a comment goes like, the so-called Sami people were nomads, they came from Sweden 100 years ago, and there's no such thing as Sami areas in Norway. Unfortunately, this comment is not unique, nor is it the worst. Land conflicts involving Sami rights often end up as discussions of who came first, and the indigenous status of the Sami people in the public sphere. In southern parts of Sápmi, the so-called advancement theory of the scientist Yngvar Nielsen from 1889 has played a central role. He claimed that southern Sami had migrated to the Røros area around 1700, and with this legitimizing the dispossession and marginalization of South Sami territorial rights. Following the theory was legislation and regulation of reindeer grazing land in the area, and more than a century of court cases still going on. I thank you for bringing up mines, because that's an interest of mine as well. And in Røros, a copper mine was established in 1644. It operated for more than 300 years. The population grew from around 15 to be one of the largest industrial societies at its times, resulting in increased necessity for land for food security for the mine workers and for their families, and wood for the mine to operate. The advancement theory has been refuted, but its legacy has lived on in the public opinion and in courtrooms, where until recently Sami knowledge, research, and culture has been marginalized, and still is to a great extent today. The narrative of late Sami immigration is necessary to reinforce private rights to win over collecting herding rights. The narrative is constantly being challenged by South Sami reindeer herders, scholars, and knowledge holders, pushing for epistemic justice and self-determination. With the green transition and the geopolitical situation in the world, there is an increased pressure to reopen old mines in the area. Incentives are given from the local governments. Mining companies and the government describe this current situation with enthusiasm for all the opportunity it brings. About the potential impacts on Sami livelihood, culture, or even presence in the area, they are silent. I will finish now. I just want to say, as a PhD student, I ask myself about my role, responsibilities and choices. And I also ask about the power of academia and the choice of academia on which stories and epistemes we listen to, engage with, and convey, and which ones we make invisible. Thank you.
Thank you, Lynn. Because I've been so strict with time, I'm going to give you the possibility, if you want to quickly react to something that you've heard before opening to the floor. We have quite a bit of time. Is there something? Anna Carolina, something you want to absolutely react briefly?
No, go ahead. Maybe Daniela would like to.
For me, we can open also.
Okay, let's open it to the floor then. Sure. This will be a panel where we actually give responses. Isn't that exciting? All right. Okay. We actually have some time to give responses. Daniela, I'm going to start with you because many of them were addressed. Everyone will have a chance to say something.
Okay, I will try to be brief, and there is, I apologize because I cannot really answer all of these questions. I will just pick up on some points, and I'm sure that we can discuss then some more after this. So just to start with the litigation processes a bit, opening that up. So I think something that's very interesting there is that of course, the Sami parliament is the first instance that decides who can vote and who can be on the electoral roll. But then they have an appeals committee, and then the appeal after that goes to the Supreme Administrative Court. And the Supreme Administrative Court in 2015, when they the Finnish one, when they started to admit many more voters, new voters that had not been on the electoral roll before. They also grounded this on supranational criticism, human rights criticism, coming from the Committee on the Elimination of Racial Discrimination, saying that the Finnish legal definition and section did not build on self-identification enough, but misunderstanding, perhaps intentionally so, this or mistaking this as individual self-identification. And you can also see that the new and the changes, so the new section and the changes have really come about when supranational institutions, human rights institutions, have criticized Finland, against the background that the Sami parliament and many Sami organizations have been saying the same things for decades. You can see also that the state really listens more to criticism when it comes from the United Nations. It's typical, I think, also in the Nordic countries that the Nordic countries have been quite actively involved on the international arena, on the international stage, when it comes to establishing rights for indigenous peoples, but there has always been kind of this assumption that this is for other indigenous peoples elsewhere, because everything is really good in the Nordic countries and there are not really any human rights problems here, and everything that we have the Sami parliaments, and then it means that things are things are okay, and not really maybe really scrutinizing what implications do these rights have also at home. And this is maybe also now what's coming back in forms of Sami mobilization. Again, on the litigation processes, and I think that this is also an intersectional point, is that one of the points that has actually been brought forward by some of the claimants is that this the state determining indigenous belonging has also hampered the leadership of the emerging leadership of Sami women in particular in the Finnish Sami parliament, and I think that's something that could be also explored further, and I think it's an important intersectional dynamic to take into consideration. On intersectional dynamics, I think also, for example, Rauno Kuokkanen has written an excellent book, Restructuring Relations. Yes, but I will give, those are just some thoughts. I will also let you speak.
Okay, yeah, I've got some very scattered thoughts, so apologies. But my first one is the South African TRC was not successful at all. No, I don't think in any way. It more famous, but it's not successful. And I think that actually is the cause of a lot of the issues around land actually and belonging, because we're dealing with a majority indigenous population and a minority colonial power. And I think that is actually the root of a lot of like the land issues, and in the sense of belonging, when it's a land where it's a majority Black, indigenous population, but the power whole is like held in the hands of a minority white population. So it's interesting, different to Sami, where it's like not an issue of recognition, but rather that of power. So yeah, that's just about the TRC. But I think I was really interested when you said indigeneity becomes bureaucratic, and I think especially when I think of specific conservation, and then you think of game reserves where like it's most often played out. The design of game reserves, the performance of game reserves, and even Kruger National Park, it's got like traditional African paintings everywhere, and you get like indigenous people to come in and to perform their indigenous culture, to say like, this is what we're here for, this is what conservation law does, this is what the point is, and those people have absolutely no power within that park. And there's there's many land claims, the biggest being for a place in the greater Kruger National Park, and that was a land claim for the community that I think was R1 billion, and very little of which the community saw has been like stolen and lost through trusts. But it really is this performance of indigeneity in these spaces where you're trying to trying to perform to mostly white middle class tourists that this is Africa, and we've got plants and we've got animals and it's beautiful, and look at these beautiful indebele, even though it's not appropriate, but they always have them there, paintings, and people come in and dance for you, and then they leave the park because they have no right over that park, despite having long histories in that park. And even recently there was some information coming out, people with graves in the park, they're only allowed to go about twice a year. You're only allowed to stay for about 15 minutes. You're only allowed to go in groups of 2. So it's even so restricted when there's proof of your history within this park, that the prioritization of, I want to say plants and animals, but really it's actually of profit. And the people who own sand parks and the private game parks in South Africa, really, it is about prioritization of that profit. Really comes at the cost of indigenous people, and their access to land that is even very easily traceable to their own.
Thank you. Who wants to go next? You want to react?
Yeah, I think that an important point is redistribution of power. And it's an important focus to understand how we can consent the exercise of rights just recognized. Thank you.
Okay.
So I think on the question about the dialectics of inclusion and exclusion, and whether inclusion implies some sort of exclusion, and what language is this framed in, and also what is including what. So I think this is a really important and fundamental question. It's not only about the language that we're using, but it's about how we think of these encounters between different societies, different social structures, alterities, which don't exist only when we talk about indigenous peoples, no? Also in other zones of encounter. And maybe we should rethink the language of inclusion. I mean, there's a concept in anthropology that's very much used in Brazilian social anthropology, which is friction. More than inclusion, you think about the friction at the boundaries of social systems, of cultures, of knowledge systems, of epistemologies. And I think that friction maintains the possibility of refusal, of acceptance, of accommodation, but also of refusal. It's much more complex than to include or to exclude. Né? So I think we should certainly think about those other ways of thinking about really radical encounters and of listening to the extent that that's possible. And we all know how difficult listening is, and we all know how difficult living with friction is, because you know, both external and internal, collective and individual, because we need to see things that we're not ready to see and that we have never seen. And I think there are so many instances and places where we're unable to do this. And so also the issue of self-determination of the other, also determining the terms with which they want to be in touch and in contact and in relation to the state or to majoritarian society or to other groups are also important points.
Thank you. And 1 minute for Lynn.
Oh, yeah. Who determines the terms? I like that. But I wanted to pick you up on the belonging part and the majority population. I come from education. I have my background in education, and I think you have a very important point. We need to start with the majority. Yes, we have this truth and reconciliation. We have the report. It's huge, but it's not being used, is my impression. We could pick it up in the classrooms. We could talk about it. We could discuss it, but for some reason, many choose not to. Of course, many do. So I think we need to start there, and curricula says that we have to include indigenous perspectives, indigenous knowledge, and also to the point about indigenous epistemologies. There's so many indigenous scholars. It's out there. It's many of them open access, so it's just to go out and look for them. So they're all accessible. So I think, again, we have a choice what we choose to engage with, and I think as a majority, we have a job to do, and we have some things that needs to be done. Yeah.
Well, big applause for the panel.